I'm not threatening you. Say one more word, and that's 30 days. 30 days.
Hey, what's going on, guys? Welcome back to Sovereign Citizens Hall of Fame with your man TP. Today, we have a treat for you for number 227 on our compilation list. We are back in the courtroom of Judge Michael Fish. You guys love Judge Fish since we've, aired him here on the channel, since we featured him here on the channel about 2 weeks ago. You guys have went sick about his videos, about the way he handles his courtroom. Well, guess what? One of the guys that we previously aired in his courtroom, Prince Pew, is back for a second appearance. So what we're going to do is we're going to put Prince Pew's first appearance and his new appearance in this compilation. And we're also going to put another appearance with Judge Michael Fish in it in this compilation. So I guess you can call this 227 a focus solely on Judge Fish's courtroom, and he is out of the state of Indiana. I know we're going to get a lot of comments on this one, so listen, let's go ahead and jump into 227.
Prince Pew, state would you please start a record?
Yes, Your Honor, thank you. This is State of Indiana versus Prince Pew. The cause number is 64D012305, ISO F54448. Defendant is present in court in person by video conferencing, is here with counsel, Mr. Steve Provost, State of Indiana by Gary Gurman.
I think it's an F6, though. That's just a typo. It's definitely 2305 F64448. Morning, Mr. Pew. Can you hear us okay?
Yes.
Okay, thank you. Mr. Provost?
Your Honor, I don't have anything new to report to the court. I haven't been able to see Mr. Pew since he was rearrested on this matter. However, I have reviewed the pleadings that Mr. Pew has filed, and I guess I'm looking to get some clarification from the court and Mr. Pew as to my office's involvement in this matter, Your Honor. From what I've read, it appears Mr. Pew is desirous of representing himself in this matter and has filed his own pleadings in accordance with that desire. But I want to be clear if, in fact, that is what he wants, and if my office should be withdrawing from this case.
Well, what happened was I entered an order striking some pleadings back in November. There were some more pleadings that were filed. I struck those in last week. And then there were some more pleadings filed, and I have a motion, or an order rather, that strikes those. But while it was in the work queue, some more motions came in. So I needed to work on the order to strike the additional pleadings that came in. We don't allow for hybrid representation in this court, Mr. Pew. So I've appointed counsel for you, and you need to file anything that would come to the court has to come through counsel. You can't file things on your own, sir. You understand that?
No, I do not understand that.
Okay, well, that's how it is. So anything you need to file has to come from your lawyer. And if it doesn't come from your lawyer, I will strike it from the record because we don't allow what we call hybrid representation. Okay?
I object.
Okay, we'll note your objection for the record, sir.
Your Honor, do we need to have any discussion with Mr. Pew on whether he wants to proceed pro se?
I don't have a motion from him to proceed on his own and without counsel.
May I ask, I understand you're not going to address it today, Your Honor, but just so I'm clear.
I mean, he hasn't filed that motion?
Yes, I filed a motion for a special appearance.
Yeah, that's meaningless to me, sir. And I struck that from the record, so it's of no moment.
Indeed, I object.
Noted. So I'm just going to set you over, Mr. Purple. Is that what you need?
Yes.
Some more time?
Yes.
My Honor, are you aware that the respondent is a national citizen to the United States of America Republic, which is a sovereign government that has its own jurisdiction? Is the court aware of that?
Mr. Pugh, I'm going to set your case over for June the 12th at 8:30, and we'll see you back here then.
I object.
Prince Pew, state would you please start a record?
Yes, Your Honor, thank you. This is State of Indiana versus Prince Pew, cause number 64D01-2305F64448. Defendant appears in court in person by video conferencing with counsel, Mr. Steve Preble. State of Indiana by Gary German.
Morning, Mr. Pew. Can you hear me okay?
Yes.
Thank you. Mr. Preble?
Your Honor, did the court get the filing just done this morning? If not, I do have a copy for the court's consideration.
You filed something?
I did, Your Honor.
I did not see anything come through my queue. Last thing I have is my order striking documents from June 9th.
May I approach?
You may. Okay. Yeah, Mr. Pugh, it looks like your attorney has requested permission to withdraw from the case.
Upon Mr. Pew's request, Your Honor.
Okay. All right. What I'll do is take that under advisement and my assumption is you intend to try to proceed on your own and without counsel. Is that correct?
Yes.
Okay, so you're asking to be able to proceed on your own and without counsel. I'm going to set this for a Faretta hearing. I will take the withdrawal of Mr. Preble under advisement pending that hearing. We will send you some documents out, or at least one document out to the jail that you can review prior to the Faretta hearing related to pro se representation. Yeah, I'm going to do that at 10:30 today. Mr. Preble, you don't need to be present for it. Mr. Pugh, I'm going to have my staff fax something out to the jail right now. They'll present that to you, give you time to review it and prepare for a hearing that'll be held here in about an hour and 20 minutes, where we'll go through your Faretta rights and make sure that you understand what would be required of you for you to be able to represent yourself before the court pro se. Okay?
Yes. For the record, my honor, did you review my documents?
Sir, you filed a bunch of stuff. The other day, I struck all that from the record because you're represented by counsel. As I've advised you before, we don't allow for hybrid representation. I would caution you, all the things that you filed that you asked me to consider, none of those, even if you were representing yourself, would be items that are pertinent to this matter, okay? So that'll be something we delve into quite deeply here in about an hour and 20 minutes, all right? Because you're gonna be expected to follow all the rules of this court that are promulgated by the Indiana Supreme Court. And if you're incapable of doing that, you will not be able to represent yourself in front of this court. So that's just a prelude, I suppose, to the hearing we'll have here in an hour and 20 minutes. You understand?
Indeed.
Indeed. We'll see you back at 10:30. All right, State, let's go back on the record for Prince Pew.
Yes, Judge, this is a resumption of our hearing earlier. It's State of Indiana versus Prince Pew, 64D01-2305F64448. Defendant appears in court in person by video conferencing without counsel. State of Indiana by Gary German.
Mr. Pew, did you have a chance to review the advice for self-represented defendants that we sent out to the jail a few minutes ago?
No, it was denied.
You didn't get a chance to review it, or you didn't receive it?
I didn't get a chance to review it because I'm not here to speak on. Yes, it was presented. Yes. Yeah, I'm not here to speak on the forever rights.
It was presented to you, but you did not review it, correct?
Yes.
Okay, please raise your hand to be sworn.
I take no other oaths beyond allegiance to the United States of America Republic.
All right, sir. Well, you have to swear in to participate in a Faretta hearing. Please raise your right hand to be sworn.
Yes, I take no other oaths beyond the United States of America Republic. I'm not a resident or I'm not a U.S. citizen, respectfully.
Right. Mr. Pew, if you don't swear in, I can't even conduct a Faretta hearing. And if you refuse to swear in and you won't go through the Faretta hearing, then there's no way you could represent yourself. So, I mean, if you can't even acknowledge that you're under oath and that you're telling the truth, then there's no purpose for us to even proceed further. I can just deny your request to proceed pro se, deny Mr.
Yes.
Pribble's.
Well, I object, Your Honor. I object, Your Honor,
and
respectfully.
go from there.
I only take an oath to the United States of America Republic.
Well, sir, let me go through the oath with you and see if it's one that you're willing to take. But what I would need you to do is raise your right hand to be sworn.
Okay.
And then what I would say to you is, do you swear or affirm to tell the whole truth and nothing but the truth?
Yes.
Okay. All right. So for the record, what is your true legal name?
Prince Pew, baby.
Okay. Is there an initial or a middle name?
Now comes the respondent, Prince Pew, baby, a national citizen through the United States of America Republic, a sovereign government that has its own jurisdiction.
Okay. I will note your refusal to give me your true legal name for the record. It appears that you are either unwilling or incapable of acknowledging your legal identity. Are you currently
I
under the
object.
influence of any alcohol or drugs?
I object. The full legal name was just given, Prince Pew, baby, on the record for the record.
Yeah. I think he spells Bay, B-E-Y.
Yes, correct.
I believe that you have a middle name, sir.
Yes, D.
Okay. Well, why didn't you say that before?
Prince D. Pew, baby.
Okay. And is Bay a name given to you by on your birth certificate or by
Yes.
birth, or was it something that was a legal name change, something of that nature?
No, it's my full name that's on my certificate of live birth.
Okay. And tell me more about your certificate of live birth.
My certificate of live birth is a birth right and customs of the United States of America Republic by me being a full-blooded Cherokee Indian.
Okay. The moniker or suffix Bay is not part of your legal name, correct?
No, that is incorrect. That is my full-blown name and appellation.
Okay. So once again, the court will note for the record that the defendant refuses to acknowledge their legal identity. All right, sir. Are you currently under the influence of any alcohol or drugs?
Once again, I object. Full name was given that's on the certificate of live birth, which is in the filing. And no, I am not
On to
under
the next question.
any intoxicants whatsoever.
Sir, are you under the influence of any alcohol or drugs? That's a yes or no question.
No,
You understand you have a constitutional right to a lawyer?
I object. I understand that my constitutional rights are being violated at this particular point.
Sir, it's also a very simple question. You understand you have a constitutional right to a lawyer?
I understand that my constitutional rights are being violated at this particular point, and I am not a resident of Porter County, nor a resident of the state of Indiana, nor a U.S. citizen. I'm a Morse American national of the United States of America Republic.
Okay, sir. You understand that you have a right to an attorney. If you can't afford one, the court would appoint one for you. Do you understand that?
No.
Okay. Mr. Pew, do you recognize that this court operates under the Constitution and laws of the state of Indiana?
No, I understand that the state of Indiana Constitution, as well as the U.S. Constitution, as well as my ordained Constitution of the United States of America Republic, is in violation at this particular point, and that you need to contact the federal government, the governor, and the attorney general at this particular point.
Mr. Pew, do you understand that and recognize the legal authority of this court to hear this case?
No, I do not. I only take oath of allegiance to the United States of America Republic. And I understand that the state cannot enforce its laws upon me and denationalize me or strip me of my citizenship or nationality. I also understand that the judge cannot sit in authority over citizens of another or a foreign state, nor can the state impair obligations of contract without being in direct, severe, gross due process violations at this particular point.
Mr. Pew, what does the prosecutor do in this court?
The prosecutor answers motions that were said that were struck down, yet I haven't had a response from the prosecutor in response to any of my motions.
Mr. Pew, what does the judge do in this court?
The judge is supposed to be a neutral party, yet is, very biased in this particular setting. And once again, the judge needs to uphold the state of Indiana, the U.S., as well as my ordained Constitution. He takes an oath of office to uphold these constitutions, and once again, cannot sit in judgment over a foreign state citizen.
Mr. Pew, tell me about the separation of powers in Indiana.
The separation of power is supposed to be, once again, within the peace treaty. The state of Indiana, as well as the U.S. Constitution, is supposed to work in a bilateral treaty with the United States of America Republic. I'm not sure if any party of interest is aware of the bilateral treaties that we have.
Mr. Pew, you understand that if you represent yourself in this court, you'll be held to the exact same standard as a licensed attorney?
No, I understand that I reserve all of my constitutional rights of the United States of America Republic. Once again, for the record, I am not a resident of Porter County, nor a resident of the state of Indiana. I'm a Moorish American national of the United States of America Republic.
Mr. Pew, you understand that in the course of you representing yourself, the court cannot and would not give you legal advice to help you try your case?
Yes, I understand that I would not be in need of any counsel coming from this appellate court in this particular case or no case at all. I'm a Moorish American foreign national of the United States of America Republic, and I have the constitutional right to represent myself pro se with any of my filings and any of my motions, and they must be heard.
Mr. Pew, you understand that criminal trials in this state are governed strictly by the Indiana Constitution, by statutes that are passed by our legislature, by the Indiana criminal rules, by the Indiana rules of trial procedure, by the Indiana rules of evidence, and other Indiana rules that are promulgated by our Supreme Court?
No, I am not a resident of the state of Indiana, nor a resident of Porter County. I understand that the statutes, the codes, the ordinances of the state of Indiana do not apply to me. Neither can the court have original jurisdiction. Only federal courts in cases where foreign state citizens and American Indians can obtain original jurisdiction.
You understand that if you intend to introduce documents or witness testimony, that you must do so by following the Indiana rules of evidence?
No. Once again, I am not a resident of the state of Indiana, nor a resident of Porter County. I understand that the statutes, the codes, the ordinances of the state of Indiana do not apply to me. neither can the court obtain original jurisdiction. Only federal courts in cases with foreign state citizens and American Indians.
You understand that if you don't know how to lay foundation, that your evidence would likely be excluded?
No.
You understand that if the state introduces evidence you believe to be improper, that you would have to object using a specific legal basis found in the rules of evidence?
No. Once again, I am not a resident of the state of Indiana. Statutes, codes, rules, and regulations do not apply to me. I'm a foreign state national of the United States of America Republic. I only take oath of allegiance to the United States of America Republic Constitution.
Mr. Pew, do you agree to be bound by and conduct your defense strictly according to the Indiana Constitution, the statutes of Indiana, the Indiana criminal rules, Indiana rules of criminal procedure, Indiana rules of evidence, and other applicable rules for criminal matters?
No. Once again, I am not a resident of the state of Indiana. The code, statutes, rules, and regulations do not apply to me. To enforce me to obligate would be a breach of trust and a breach of fiduciary duties of obligations and duties, as well as a breach of contract, according to Article 1, Section 10 of the Constitution.
Mr. Pew, you understand that if there was a trial held in this matter, that I might make rules on objections and rulings on motions. Do you agree to respect and abide by the rulings, even if you disagree with the court's rulings?
No. Once again, the code, statutes, rules, and regulations do not apply to me. What the court needs to do is contact the federal government, the governor or the attorney general of the state of Illinois. Because right now, the state of Illinois, the state of Indiana Constitution, as well as the U.S. Constitution, is in violation at this particular point.
Sir, will you refrain from raising legal arguments, filing motions, or making statements to the jury that rely on jurisdictional theories, commercial law, or alternative legal codes not recognized by the state of Indiana?
No, I will, because I cannot be denationalized and I cannot be denied citizenship. The only thing that I'm here to discuss is the treaty and the treaty that we have. So no, that would not be something that I will do. All of my motions are to be heard within the court and to be responded to by the plaintiff.
All right, Mr. Pew, I must advise you that in my professional opinion, it's almost always unwise to represent yourself in a criminal matter. In this case, you're facing a level 6 felony, which carries a possible sentence of 6 months to 2.5 years in prison, and then an additional charge for resisting law enforcement, Class A misdemeanor, which carries an additional sentence of up to a year in jail. You understand the potential penalties you're facing here?
Respectfully, my honor, the consulate manual, page 61, is in violation because no one has contacted my consulate. And, you know, with that, it's a supreme violation of my political and constitutional rights. Once again, resulting in a breach of trust, a breach of fiduciary duties and obligations, according to Article 1, Section 10 of the Constitution. Once again, I reserve all of my constitutional rights in the United States of America Republic. So I demand at this particular time, my honor, respectfully, for a constitutional review to avoid due process and constitutional civil rights violations, as well as my civil liberties, respectfully.
Mr. Pew, you realize that a trained lawyer could identify your defenses, constitutional violations that you might miss, and that not having a lawyer could result in a severe disadvantage to you under these circumstances?
No, this is where the judge, being a neutral party, is to uphold and make sure that my constitutional rights are not being in violation. I also demand that without proof of jurisdiction, the court cannot proceed, and I demand for dismissal of this case for lack of jurisdiction for the record.
Okay, we'll deny your motion to dismiss, sir. Firstly, it's not done in writing. Secondly, you are represented by counsel still. in this matter because I haven't made a determination about your counsel, and we don't allow hybrid representation. And thirdly, there's no basis in law for your motion to dismiss.
Well, I object to any counsel entry on behalf of any merits on the record for the record.
Mr. Pew, you understand that you're under severe disadvantage if you choose to represent yourself and you don't follow the strict rules that this court would require you to follow. Knowing that, is it your clear and voluntary desire to represent yourself?
Yes, it is my clear right to represent myself, and no, once again, the code, statutes, rules, and regulations do not apply to me, so I do not acknowledge any rules of the court that would mandate me not to be able to represent myself as I see fit.
Okay, tell me more about your wish to represent yourself pro se.
Well, it's nothing more to discuss beyond me reserving all of my constitutional rights as a foreign state citizen and a full-blooded Cherokee Indian of the United States of America Republic.
Okay, well, sir, I will deny your request to proceed pro se. I will deny Mr. Pribble's motion to withdraw as your counsel. I will make the following findings. I'll find that you have failed to make a clear and unequivocal request to proceed pro se.
Yes, I object.
Responses to the court's inquiries were evasive, conditional, or reliant on legal theories not recognized by this jurisdiction. And
yes,
as a
I
result,
object.
the court cannot find a definitive waiver of the right to counsel.
Yes, I
The
object.
court finds that the right to self-representation is not a license to disregard the procedural and substantive laws of Indiana. During the colloquy, the defendant expressly refused and demonstrated an inability to agree to be bound by the Indiana rules of trial procedure, the Indiana criminal rules,
I object.
Indiana statutes, the Indiana Constitution, and Indiana rules of evidence. And
I
that the
object.
defendant who will not agree to follow the established rules of this courtroom cannot effectively waive the right to counsel and conduct a defense.
Yes, I object, Your Honor.
That to validly waive counsel, the defendant must possess a rational understanding of the proceedings. Based on defendant's answers regarding the constitutional authority of this court, the branches of government, and the respective roles of the judge and prosecutor, the court finds the defendant fundamentally misunderstands or refuses to acknowledge the nature of these proceedings. Consequently, any waiver of counsel is not knowing or intelligent.
I object, Your
I
Honor.
also find that the defendant, allowing the defendant to proceed pro se would fundamentally disrupt the administration of justice. The defendant's conduct and statements during this hearing indicate a persistent intent to challenge the foundational jurisdiction of the court rather than present a defense to the charges. As established in the Hotel F v. State case, the right to self-representation does not protect obstructionist behavior that presents the orderly progression of a trial. I will also find that the defendant's persistent refusal to directly answer the court's basic questions, including questions regarding their identity, their understanding of the charges, their understanding of the appropriate laws and rules that apply in the court, frustrated the court's ability to conduct a meaningful Faretta colloquy, and because
I
of the
object, Your Honor.
non-responsiveness, prevented the court from establishing that a waiver of counsel was knowing, voluntary, and intelligent. Sir, as I mentioned before, we're denying your motion to proceed pro se. I'm denying your defense counsel.
I object, Your Honor. Is that an order that you can have in writing?
State of Indiana versus Michael Allegretti, 64 D01 2509 F2 10947. Defendant is pro se. State is represented by Deputy Prosecutor Hammer. We were set today for, I believe it was a Faretta hearing.
It is Faretta. Mr. Allegretti wants to represent himself. Sir, did you get a copy of our pro se representation form?
Yes, I did, Your Honor.
Did you have a chance to review that?
Yes.
Did you sign it and stuff?
No, I did not.
No? Do you have it with you?
No, I'm not going to sign it. I'm here, if I may speak, Your Honor. I'm appearing in persona, propria persona, especially not generally. I do not submit to the jurisdiction of the court as a defendant.
Okay, Mr.
But-
Allegretti, that's all you need to say. If you're not going to submit to the jurisdiction of the court, you cannot represent yourself pro se. I'll appoint the Porter County Public Defender Service to represent you.
No,
And you
can
will
I
have
finish
counsel.
talking?
I'm sorry, sir. What you're saying is that you will not subject yourself to the jurisdiction of the court. What that tells me is that you're not capable of representing yourself, because when you represent yourself in this court, you become to the same level as an attorney, okay? Because you are unwilling to subject yourself to the jurisdiction of the court, you cannot hold that status. Do you understand, sir?
No, I do not.
Oh, that's all you need to know. I'll appoint the Porter County Public Defender Service to represent you. You're welcome to hire
I
counsel.
will not be
if you're
accepting that,
choosing.
Your Honor.
You are accepting it, sir. You know what direct
I wanted to
contempt of
put, I
court
wanted
is,
to
sir?
put my other stuff on the record, if you don't mind.
I will not allow you to put any garbage like what you're about to say on the record.
Okay.
You have filed documents in front of this court. You have boogered up my court docket with your pro se filings over the last couple of weeks. I've had to write orders that struck those from the record. None of that is of record because it was stricken. And I have your mail here that you apparently don't even have the correct address for the court. What's your address, sir? Do you know what direct contempt of court is, sir?
Yes.
Direct contempt of court is when you are in contempt of these proceedings. And one way that you can be in contempt of court is if you refuse to answer questions and you delay the proceedings in front of this court.
Yes.
And you're refusing to answer questions that are as simple as, what is your address? And we need to know the address for the official court record.
My
Understand that, sir?
Yes.
What's your address?
702 Indianapolis, Indiana.
What's the zip code?
46260.
Just so you're clear, do you know what the penalty is I can give you for direct contempt of court?
No.
Up to 6 months in jail with no good time credit. You understand that?
Yes, Your Honor.
Okay. So you're clear. I struck your frivolous proceedings from the record a few days ago, which may result in the denial of your request to represent yourself, which I have already done. Okay. So I denied your request to represent yourself. I've appointed counsel for you.
I do not understand those.
What'd you say?
I don't understand this proceeding, and I don't understand the charges.
I'll get back to that in a minute.
Okay.
The second thing I notified you is that I may exercise my inherent authority to impose filing restrictions on you to prohibit you from filing any future pro se documents without prior judicial screening and approval. I've taken care of that because I've appointed counsel for you. And you're not allowed to do what's called hybrid representation. You're not allowed to also file things at the same time you're a lawyer's filing things, because they're responsible for anything that would come to this court. Do you understand? So any motion
I do
that
not
they would
understand.
file. What did you not understand? The words I used or what they mean?
Everything.
What's your level of education, sir?
I had some college.
Okay, so you graduated from high school?
No, I did not have a GED.
You have a GED? So you graduated from high school? You have a equivalency
Yes.
of a high school graduation?
Yes.
Okay. So what I said was that you're not allowed to do hybrid representation. Do you know what hybrid means?
Nope.
Hybrid means that there are two ways, right? Hybrid would give the understanding that you're also representing yourself pro se at the same time you have a lawyer.
I do
Understand
not
what
have a
that means?
lawyer, though.
I just appointed a lawyer for you.
But I don't want it.
You have it because I denied your right to
I can't
represent
afford
yourself.
one, and I don't want a court-appointed attorney that's represented under the Bar Association.
Sir, the first words you told me was that you don't plan to submit yourself to the jurisdiction of the court. As a result,
I wasn't able to finish.
I
said as a defendant.
well, sir, you have to submit yourself to the jurisdiction of the court. That's the kind of nonsense that I think you're involved now with some program that you probably don't want to be if you want to try to represent yourself in front of this court. But in any case, the third thing I told you is I can impose further sanctions for contempt or abusive litigation practices upon you. You understand what that means?
No, I do not.
I can hold you in contempt of court for delaying these proceedings, and I can sanction you for abusive litigation. All right? And the fact that you've now tried twice to file the documents that I've had to strike from the record tells me that you're willing to be an abusive litigator. Do you understand that?
I do not.
Okay. So I have time that I work on cases. Everything's pretty streamlined for the most part. People understand how the rules work. When they represent themselves, they make themselves apprised of all those rules, and they're held to the same standard that lawyers are held to. As a result, things run fairly smoothly, and we have some thousands of cases that we handle each year. Because people follow the rules, they abide by our processes, we're able to get our work done in a relatively streamlined fashion. What you're suggesting to me is that I shouldn't do that. What you're suggesting to me is that I should, for your specific case only, have some special rules and allow you to somehow opt out of your given name, opt out of the processes and procedure of this court, and allow you to proceed as your own sovereign or something of that nature. Is that correct?
Yes, Your Honor.
Correct. Right. And we can't have that. You know
Your
why?
Honor, but if you
Because
just let me
it
finish.
doesn't follow the rules of court procedure. And
But I'm in
therefore,
equity, Your
you're
Honor.
going to follow the rules of court procedure. And if you want to abide by those procedures, you'll be fine. If you don't abide by those procedures, you'll be in contempt. You understand?
I still don't understand the proceedings and the charges of this matter or the proceeding.
Okay, sir.
I just want to put that on the record.
Well, we're going to sit here until you understand, or until you at least acknowledge you understand. And if
That's
you don't,
fine, Your Honor. I had the day off of work.
say what?
I have the day off of work. I can stay.
Okay. So count one says that you're charged with dealing cocaine. It alleges that on or about September 28, 2025, here in Porter County, you did knowingly or intentionally possess with the intent to deliver or finance the delivery of cocaine or narcotic drug, and the amount was at least 10 grams, contrary to the form of statute. You understand the charges in count one?
No, I do not.
What do you not understand, sir? The words I used or what they mean?
What is the definition of understand in the law?
Sir, you have to just acknowledge whether or not you understand.
I don't understand, though.
Which part do you not understand?
I don't understand all of it.
Okay, well, let me go through it again. Count one suggests that you dealt cocaine, a level 2 felony. You understand what a date would be, September 28th of 2025?
I still don't understand.
Sir, do you not understand what date would be, September
I
28th
understand
of
that
2025?
I accept your date, but I don't understand the natures of these charges.
Okay, sir, you're about this close to being held in contempt of court. You understand that?
I understand, Your Honor.
And if you're held in contempt, I'm going to put you in jail, sir. And I'm going to jail you.
Why
until
are you
tomorrow.
forcing me to understand the charges?
I'm not forcing you to, sir.
Yeah, why
I'm
would-
just
if you're just going to give me an
trying to
attorney.
go through the statutory and constitutional procedures required of me in this court. And that's for me to make sure you have a knowing and voluntary, well, not knowing and voluntary, but you have an understanding of the charges filed against you. It's part of your constitutional requirement.
And if it is, I do have rights too, right?
Well, I've gone through your rights with you. You understand that you have certain rights in this case?
Yeah, do not.
I'm
Do
required to advise you of your various rights in this matter.
Am I
You have the
allowed?
right to hire an attorney to represent you. You understand that?
And I do want an attorney.
Well, you understand that you have the right to one, or you wouldn't be able to suggest that you don't want one, correct?
I don't want one.
So you
I don't
understand
want-
you
I
have the
don't-
right to one, correct?
Correct.
Okay. And you understand that if you can't afford one, the court will appoint one for you, correct?
If that's what you say.
Oh, no, sir. You either understand or you don't. You understand?
I understand that you want to give me a court-appointed attorney.
No. I already appointed a court-appointed attorney for you because you can't get through the Faretta hearing. You understand why you can't get through the Faretta hearing?
No, I do not.
What were the first words out of your mouth when you read off your card earlier?
I said I'm in pure persona,
And then?
especially and not generally. I do not submit to the court's jurisdiction of the court as a defendant.
And that's all I need to hear, sir. That's all I need to hear, because if you're not willing to submit yourself to the jurisdiction of the court, you cannot represent yourself in front of this proceeding. Do you understand that, sir? You know what jurisdiction is?
Yes.
Tell me about it.
You think that you have jurisdiction over my body, and I'm a living human
What does
being.
it mean, sir?
Are you here to practice court? Are you, I don't understand what this has to do with anything.
I'm asking the questions, and I don't care whether you think you understand it or not. You've come up here with your sovereign citizen.
I'm not a sovereign citizen. I did not claim to be a sovereign citizen.
Trying to bring
I'm using the law in equity.
confusing sort of pseudo-legal jargon into the court, arguing things that aren't even based on criminal law.
I didn't even get to
and
finish my
suggesting
statement.
that you're not willing to subject yourself to the jurisdiction of the court.
I didn't
As a
even-
result, you can't have a lawyer. I'm sorry, you can't represent yourself. You have to have a lawyer, somebody who understands how the court proceedings work and is an officer of the court already. You understand that?
No, I do not.
Which part don't you understand, sir?
Everything. I can't even state my statement. I want to just put my statement on record.
You're not willing to subject yourself to the jurisdiction of the court. You're not capable of representing yourself, and you must have counsel.
I said as a defendant, Your Honor.
Sir, I don't care how you try to qualify it. All right, sir, do you understand the allegations in count one
No, I do not.
related to the possession of cocaine?
No, I do not.
Okay. I'm going to give you another chance to explain to me, what do you not understand?
I don't understand the charges. I don't stand under the charges. If that's what we're talking about, I do not stand under these charges.
I'm willing to hold you in contempt, and we can handle this again tomorrow, okay? So what I will do, Mr. Allegretti, is find that you've unduly delayed these proceedings.
All I want to do
Find
is
you in
speak my-
direct contempt of court for your continuous delay of the proceedings. I'll sentence you to a day in the Porter County Jail for your
Your Honor, I
contempt.
have a job.
Please take Mr. Allegretti into custody. We'll try again tomorrow, sir. We'll be adjourned in F2-10947, and I'll open a new case on the contempt proceeding. Lawyers are trained to recognize objectionable and unfavorable evidence and promptly object to their use. They're capable of presenting, as I mentioned, favorable sentencing information and attacking unfavorable sentencing information. In a jury trial, a lawyer will give an opening statement and make a closing argument, and they're capable of doing that very artfully. Have you ever had experience speaking in front of people?
I'm doing it right now.
Have you ever had experience speaking in front of a large group of people?
Yes,
such
I
as-
have.
Okay, tell me about that.
I can't remember.
Okay,
I don't know how to articulate it is what I actually mean.
well, you would articulate it by telling me what experience you have.
I've been in front of people where I've spoke to a group of people before,
How many people do you think were in that group?
at least 25 plus.
Okay, and how many, how
It's a
often,
presentation.
how often have you had the opportunity to do that?
More than a handful of times.
How many is more than a handful? 6?
I have no idea. I cannot give you, that would be lying.
Okay. The other thing that a lawyer would do in a trial is help the court prepare jury instructions and select a jury. You understand how to select a jury?
Yes,
What would you do in that circumstance?
I would cross-examine them.
You would. Lawyers have the training, knowledge, and skill at properly preserving the record of a case for appeal. Have you ever been involved in an appeal?
No,
An attorney can also evaluate the strengths and weaknesses of the case against you and give you expert advice on whether you should attempt to seek a plea agreement, which might result in a dismissal of some of the charges or a recommendation of a favorable sentence in return for your plea of guilty. This is an important part, and I would ask you to take note that you will If you decide to not have an attorney, you'll not receive any special treatment with your defense. You'll have to follow all the same rules and procedures in your case as an attorney would have to. The state will have a competent attorney. As I told you, you have a right to decide against having an attorney, but you must be aware that deciding not to have an attorney can turn out to be a very bad decision. Experienced lawyers almost would always decide to be represented by another lawyer in a criminal case. There are some of the things that you should consider before you appear at trial without an attorney, and I want to go through a little bit more now. Tell me more about your skills and knowledge that you have that you believe would be helpful in representing yourself.
Where do you want me to begin? Ask me a question and I'll answer it.
I ask you a question, sir. What skills or knowledge do you have that would be helpful to you in this regard?
I'm able to learn quickly and I know I can represent myself.
What's your college work? And you mentioned you had some college work.
Personal training as a personal trainer.
Okay, like in a gym or something like that? When you work in the gym, do you work with people, interact with people?
Yes, all the time. I did.
Do you still have that job?
No.
What other work have you done? What other career have you had?
I worked at a pharmaceutical company where I led teams. I developed drugs and I was promoted multiple times as team leader to a supervisor.
To what degree did you lead people?
We led multi-million-dollar studies that had my name attached to those, to where I had a lot of responsibility and I had to learn fast and move fast.
Have you ever studied criminal? Go ahead.
Well, I never was in the pharmaceutical company, so I learned fast and I only had that job for 3 years, and I was able to propel myself that quickly with the little knowledge I had.
Have you ever studied criminal law?
I'm studying it now.
Have you ever studied criminal law previous to now?
No.
Have you ever had previous experience in the criminal justice system?
Yes.
What's the experience you've had in the criminal justice system?
When I was dealing with previous cases in the early 2000s.
Okay, tell me more about that.
I submitted to whatever the court told me to do. What do you mean?
What type of case were you involved with?
Drug cases.
Okay. And is that a case or cases where you were charged with crimes?
Yes.
And are those cases where you came to court?
What's that word mean? Caped, where they represented me?
I said came.
Oh, came, sorry.
Came to court? Did you have to come to court for those?
Yeah, yes, I did.
And did you have an attorney?
Yes, at that time.
Okay. Did you go to trial?
No.
So what was the result of the case?
I pled guilty to those charges.
Okay. Is that the limit of your experience in a criminal case?
Yes.
All right. You believe you're able to read a lot of information and
Yes.
digest a lot of information?
Yes.
What about your writing ability?
Yes.
Tell me more about your ability to write.
I wrote up all those. I wrote up all those notices. You didn't read them?
You wrote some documents and
Yes.
filed those with the court on 2 separate occasions.
Yes.
I struck both of those filings from the record because.
Yes. But that's the degree that I'm on.
Okay, so how did you compose those?
I wrote them.
And what did you use as reference?
Equitable law.
Okay, you understand this is not a court of equity?
You're telling me that that all courts are not with equity? No court in Indiana is equitable?
This is not an equitable proceeding here. Absolutely not. This is a proceeding at law.
Okay. Well, I represent myself under equitable law.
Well, we make I think, fine distinction in Indiana between what are equitable cases and what are cases at law. And this one most assuredly is a case at law. You're entitled to a jury trial. You understand that in an equitable case, you're not entitled to a jury trial? You understand that?
Yep.
You do?
You're telling me now.
Okay.
I'm learning as I go.
Okay. You understand that if you represent yourself, you'll be proceeding as the single legal entity named in the charging information, specifically Michael Corleone Allegretti.
That's not my name.
You understand that the court won't entertain any arguments to the contrary.
If that's what you're telling me.
Okay? Is that a yes or a no?
I understand that.
No. What I asked was whether or not you are aware that the court will not entertain arguments to the contrary. Your name is Michael Corleone Allegretti. That is your legal name.
That's not my legal name. I changed it.
Do you have documentation that you
Yes,
changed
I
your
do.
name? Please don't cut me
I'm
off.
sorry.
Where did you get that documentation?
In Michigan.
In the state of Michigan?
Yes.
And you have a court order that changes your legal name?
Yes, I do.
Where's that documentation?
In my files. I had it in my possession yesterday.
Okay. Well, in this order today, will order you to provide the change of name
I will.
order from the state of Michigan to the court
I have no problem.
within, say, 10 days.
I can do it today.
And then, well, I'm going to give you 10 days.
Okay, thank you.
And then have you not changed your driver's license?
Not yet. I'm still in the process of doing everything.
When did you have the hearing that resulted in the name change?
I put it on my documents when I gave you the notice of intent. I put it on my documents then. Do you still have the copies?
How recently was it?
I don't remember the exact date.
Did you have to go to court in Michigan for it?
Yes.
You don't remember when it was?
I don't know the exact date, no.
Were these charges
I gave you all the documents, sir.
were these charges already filed at that time?
Yes.
You also, in those filings, suggested you're making a special appearance or that you do not consent to this court's jurisdiction. You understand that in a criminal proceeding, your personal consent to the court's jurisdiction is not legally required.
Say it again.
Do you understand that in a criminal proceeding in Indiana, your personal consent to the court's jurisdiction is not legally required?
No, I don't understand that.
Okay. Do you understand that the state of Indiana has jurisdiction over the charges filed against you, and this case will move forward regardless of whether you agree with that jurisdiction?
I don't understand that either.
Okay. You seem to be clever enough to understand these things. I asked you earlier whether or not you're suffering from a mental health condition. I predict that at a certain point, if you continue to suggest you don't understand simple terms, that your attorney will suggest to me that I need to have you evaluated for competency. Do you understand that that's a possibility here?
Nobody's speaking for me. He's not my legal representation.
Oh, he is. Do you believe that you are incompetent and incapable of proceeding on because of a mental incapacity?
No.
Do you believe you understand the players in the courtroom?
What players?
Do you believe you know what I do as the judge?
I believe you're an actor.
The other thing that you put in the record, you attempted to apply concepts like suretyship, subrogation, demands for accounting, and different things like that in these criminal charges. And as recently as a few minutes ago, insisted that you're dealing with an equitable case here. You understand that the Uniform Commercial Code, civil contract law, and commercial equity have absolutely no application in this criminal prosecution?
I'm just here to settle the matter and put my stuff on record that you already struck. How come we're going over it if you already struck it?
Sir, it's an important part of the Faretta determination. I can't allow you to represent yourself if you can't answer affirmatively to these questions. And you've already not answered affirmatively to 2 out of the 4 that I have here that I want to make sure that we go through. You understand that?
No.
Okay. Well, what I said was, and I just want to make sure our record's clear, the UCC, civil contract law, commercial equity have no application in this criminal prosecution. And you understand that the only rules that apply here are the Indiana Rules of Criminal Procedure, the Indiana Trial Rules as they're brought into those criminal procedure rules, Indiana Rules of Evidence, and substantive criminal laws of the state, along with various other administrative rules that we have to abide by, including our jury rules. You understand those are the only rules that apply in this case?
I understand now.
You do understand?
I understand what you just said.
Okay. You understand that if you are allowed to represent yourself, you'll be held, as I mentioned, to the exact same standards as a lawyer, as a licensed attorney.
Am I ready to talk? I'm sorry.
I'm just waiting on your response.
Oh, yeah. Yes.
And you understand that I will not permit you to waste the court's time or the jury's time by raising the theories that you've raised thus far, commercial law defenses, or challenging, say, the capitalization of your name, for example?
Do you want me to answer?
It was a question. You
Yes.
understand that?
Yeah.
And you understand that if you attempt to use your self-representation to file frivolous documents, disrupt proceedings, or refuse to follow rulings on issues, I'll find that you've forfeited your right to represent yourself and will appoint counsel to take over your defense.
Are you going to give me examples of frivolous? Because I won't know until I file them.
Well, the two attempts you've made to file documents previously were both deemed to be frivolous.
So should I just bring them to you directly and then you'll let me know?
I haven't made that ruling yet to require screening before filing, but it's on the horizon if you continue to file things that have nothing to do with the criminal case. Okay. So because you answered no to the first couple questions, you really aren't capable of representing yourself. And I do think that my ruling yesterday was correct. It seems that you're unable or unwilling to abide by the rules of procedure and substantive law. And I don't think that you can make a valid waiver of counsel. The court had spent some time yesterday afternoon reviewing a case, Hotep L v. State of Indiana. And I think that's an adequate Faretta inquiry. Again, I think I must deny your request to proceed pro se. The court does not, well, I'll phrase it the opposite way. The court specifically finds the defendant's request is not a genuine attempt to present a legal defense, but a calculated strategy to obstruct and subvert these proceedings. Defendants utilizing the rhetoric of what is commonly referred to as the sovereign citizen movement, including raising nonsensical challenges to subject matter jurisdiction, attempting to apply commercial law to a criminal prosecution. The right of self-representation is not a license to abuse the dignity of the courtroom or ignore relevant rules of procedure and substantive law. Based upon the filings that were previously stricken and the statements in open court today, court finds that the defendant's unwilling to comply with the rules of procedure and intends to use self-representation solely for the deliberate disruption of the proceedings. So I will deny the request to proceed pro se. I will maintain the appointment of counsel of Mr. Patton. And I think that will do it. We need to get some hearings. We need to get a hearing on the calendar.
I want to object to your ruling on the record.
So noted. Did you want to add anything to your objection?
I know I can represent myself.
I'm not threatening you. Say one more word and that's 30 days. 30 days.